Everyone, I am Godfreya Rasha M. Lapos and I'm going to discuss the case about Ariel Non Rex Magana versus Honorable Sancho Dames II, May 20, 1990. So first, I'm going to introduce to you the background of the case. So, petitioners urge the court in Bank to review and reverse the doctrine laid down in Alqua's Philippine School of Business Administration 76, 35, and 3 on May 2, 1988. So, to the effect that a college student once admitted by the school is considered enrolled only for one semester and hence may be refused readmission after the semester is over. So, as the contract between the student and the school is deemed terminated. Petitioners, students in private respondent Mabini Colleges Incorporation in the Camarines Norte were not allowed to re-enroll with the school for the academic year 1988 to 1989 for leading or participating in student mass actions against the school in the preceding semester. So, the subject of the protest is not, however, made clear in the pleadings. So, petitioners filed a petition in the court seeking their readmission or re-enrollment to the school. But the trial court dismissed the petition in an order dated August 8, 1988. So, the dispositive portion of which reads, "Wherefore, premises considered at the fact that the ruling in the Alquas versus PSBA is exactly on the point at issue in this case but the authority of the school regarding admission of students. So save as a matter of compassionate equity, when any of the petitioners would at the least qualify for re-enrollment, this petition is hereby dismissed." After introducing the background, I will proceed to facts, issues, and ruling of the cases. So, petitioners filed a petition in the court seeking the readmission or re-enrollment to the school. But the trial court dismissed the petition in an order dated August 8, 1988. So, the dispositive portion of which reads, "Petitioners' claim of lack of due process cannot prosper in view of their failure to specifically deny respondents' affirmative defenses that they were given all the chances to air their grievances on February 9, 10, 16, and 18, 1988, and also on February 12, 1988, during which they were represented by Attorney Jose L. Lapac, and that on February 22, 1988, the date of the resumption of classes at Mabini College, petitioners continued their rally, picketing even though without any renewal permit, physically coercing students not to attend their classes, thereby disrupting the scheduled classes and depriving a great majority of students of the right to be present in their classes. So, against this backdrop, it must be noted that petitioners waived their privilege to be admitted for re-enrollment with the respondent college when they adopted, signed, and used its enrollment form for the first semester of the school year 1988 to 89. Said form specifically states, "Initially, the case of bar must be put in the proper perspective. This is not a simple case of a school refusing readmission or re-enrollment of returning students. Undisputed is the fact that the refusal to readmit or re-enroll petitioners was decided upon and implemented by school authorities as a reaction to student mass actions directed against the school. So, petitioners are students of respondent school who, after leading and participating in student protest, were denied readmission or re-enrollment for the next semester. This is a case that focuses on the right to speech and assembly as exercised by students vis-a-vis the right of school officials to discipline them. The student does not shed his constitutionally protected rights at the school gate. So, petitioners invoke their rights to peaceable assembly and free speech. They are entitled to do so they enjoy, like the rest of the citizens, the freedom to express their views and communicate their thoughts to those disposed to listen in gatherings such as was held in this case. They do not, to borrow from the opinion of Justice Fortas in Tinker versus Des Moines Community School District, shed their constitutional rights to freedom of speech or expression at the school gate. So the academic freedom enjoyed by the institutions of higher learning includes the rights to set academic standards to determine under what circumstances failing grades suffice for the expulsion of students. Once it has done so, however, that standard should be followed meticulously. It cannot be utilized to discriminate against those students who exercise their constitutional rights to peaceable assembly and free speech. Permissible limitations on student exercise of constitutional rights within the school. So while the highest regard must be afforded the exercise of the rights to free speech and assembly, this should not be taken to mean that school authorities are virtually powerless to discipline students. This was made clear by the court in Malabanan when it echoed Tinker versus Des Moines Community School District, but conduct by the student in class or out of it, which for any reason, whether it stems for time, place, or type of behavior, materially disrupts classwork or involves substantial disorder or invasion of the rights of others, is of course not immunized by the constitutional guarantee of freedom of speech. Circumventing established doctrine. So, Malabanan was decided by the court in 1984. Since then, student mass actions have escalated not only because of political events that unfold, but also because of the constantly raging controversy over increases in tuition fees. But the overeager hands of some school authorities were not effectively tied down by the ruling of Malabanan. Instead of suspending or expelling student leaders who fell into disfavor with school authorities, a new variation of the same stratagem was adopted by the latter, refusing the students' readmission or re-enrollment on grounds not related to their alleged misconduct of illegal assembly in leading or participating in student mass actions directed against the school. Thus, the spate of expulsions or exclusions due to academic deficiency. The nature of the contract between a school and its student. The course in Alquas anchored its decision to the termination of contract theory, but it must be repeatedly emphasized that the contract between the school and the student is not an ordinary contract. It is imbued with the public interest, considering the high priority given by the Constitution to education and the grant to the state of supervisory and regulatory powers over all educational institutions. On the other hand, it does not appear that the petitioners were afforded due process in the manner expressed in Guzman before they were refused re-enrollment. In fact, it would appear from the pleadings that the decision to refuse them re-enrollment because of failing grades was a mere afterthought. It is not denied that what anchored the ire of the school authorities was the student mass actions conducted in February 1988 and which were led and or participated in by the petitioners. However, this should not be taken to mean that no disciplinary action could have been taken against petitioners for breach of discipline if facts that so warranted. In line with the court's ruling in Malabanan, petitioners could have been subjected to disciplinary proceedings in connection with the February 1988 mass actions, but the penalty that could have been imposed must be commensurate to the offense committed and is set forth in Guzman. It must not be imposed only after the requirements of procedural due process have been complied with. But this matter of disciplinary proceedings and the imposition of administrative sanctions have become moot and academic. Petitioners who have been refused readmission or re-enrollment and who have been effectively excluded from the respondent's school for 4 semesters have already been more than sufficiently penalized for any breach of discipline they might have committed when they led and participated in the mass actions. that, according to respondents, resulted in the disruption of classes. To still subject them disciplinary proceedings and would serve no useful purpose and would only further aggravate the strained relations between petitioners and the officials of respondent school, which necessarily resulted from the heated legal battle here, in the Court of Appeals and before the trial court. The case of Ariel Non Rex Magana versus Honorable Sancho Dames II on May 20, 1990 involves a group of students who were refused re-enrollment in their school, Mabini College, allegedly due to academic deficiencies and breaches of discipline. The students argued that their academic deficiencies, if any, did not warrant non-readmission and that the improper conduct attributed to them was during the exercise of their rights to free speech and peaceable assembly. They also claimed that they were not afforded due process before the decision to refuse their re-enrollment was made. The Supreme Court of the Philippines ruled in favor of the students. The court found that the 5 students who did not incur failing marks were refused re-enrollment without just cause and should be allowed to re-enroll. The court also noted that it did not appear that the students were afforded due process before they were refused to re-enrollment, which constitutes a violation of the basic tenets of fair play. The court also stressed that excluding students because of failing grades when the cause for the action taken against them undeniably related to possible breaches of discipline is not only a denial of due process but also constitutes a violation of the basic tenets for fair play. The implications of this case to education are significant. It emphasizes the importance of due process and fair in educational institutions. It also highlights the need for schools to provide clear and justifiable reason when refusing a student's re-enrollment. Furthermore, it underscores the recognition of students' rights to free speech and peaceable assembly and the need for schools to respect these rights. This case also serves as a reminder for the educational institutions that while they have the prerogative to set academic standards, they should not use these standards to discriminate against students who exercise their constitutional rights.